Was your Canada visa refused? Then you need to listen. When a visa is refused, it can be quite upsetting, but it's important to stay calm and decide on which way to go. There are a few things you can do. I'll say there are mainly three. The first one will be to reapply. Second one will be to seek reconsideration. We call it sending a reconsideration request. And the third one will be a judicial review. You may ask, why do refusals happen? Why have they refused your application? Well, it could be because the application is deficient to start with, but on the other hand as well, it could be because the visa officer, the decision maker, has made some errors. It could be an error in fact, and it could be an error in law. So, I mean, you may say, but they're visa officers, right? They're the government. Why should they make mistakes? Well, at the end of that, RCIC banner and the government are humans, just like every one of us. So humans do make mistakes, hence the word human errors. So the errors could come up because, you know, like in all sectors in Canada, there is labor shortage. RCIC has had many recent visa officers, and while they train them, they don't have the experience and the time it takes to learn some things, and while they're looking at applications, they do make errors. So when those errors are made, that is why you would need this tools to fix it, whether you're reapplying or reconsidering or doing a judicial review. Which one you decide to do would actually depend on the reasons for the refusal and the merits of the case to start with. I'll start with reapplying. For instance, the reason for refusal is that something wasn't included and that particular document or information is critical to the eligibility for that application. For instance, you apply for a visitor visa and there was no invitation letter and they maybe refused based on the purpose of visit. Perhaps it might be better to actually reconsider your purpose of visit, maybe get an invitation letter, plan your itinerary better, and then reapply. Next, reconsideration. When you decide to do a reconsideration request, it would be that there's been an error in fact or law. Now, an error in fact, I'll give you an example of a client where a job offer was made by a business. The business is in a complex that is 6652 to 683, let's say ABC Road, right? And while her business is actually on the 683 and not on the 665, she used 665 in all of the job offer letters, the PD7As for the business, and that's because that was the way she bought it over from the previous owner. Now, while in the application, and she herself didn't even know about this, while in the application, if she had written the address as 665 to 683 ABC Road, perhaps RCC wouldn't have said the business does not exist at that location, but instead she inherited the previous owner, saying that the address is 665 ABC Road. But her building in particular, where the business is situated, is actually the 683 ABC Road. So in that particular scenario, we then did a reconsideration request, laying out why the business is actually in the address, which is the 665 to 683 ABC Road. And IRCC should have given her an opportunity to respond to their concern. We call it procedural fairness in law. So we put together this reconsideration request, pointing out the error in law, the error in fact, because then they said the business does not exist in that location and so on. And the case was actually approved and the client is today a permanent resident. So reconsideration requests can be very important. There are many examples I can give, but let's stay with just that one. The third thing you can do if you've been refused is the judicial review. I'll take a moment to explain what the judicial review process is. Basically, a decision has been made by a decision maker, most likely a negative one, and the applicant and their legal counsel wants to challenge that decision by taking it to the federal courts and put the case in front of a judge, where the judge would hear both sides and make a ruling to say, I agree with the minister's counsel, or I agree with the applicant and their counsel. So in order to decide that your application is worthy to go further to that judicial review process, it would mean that that application was well done and all of the criteria for that particular application were well met. So I always would use the word a judicial review worthy application. So especially if you've had a previous refusal, it is likely that subsequent applications could be refused. So that is the point where you have to backtrack and say, am I getting the right help from a licensed professional to make sure that your application is judicial review and can go in front of a judge and you have the potential and the possibility to win.